Today, we're going to be talking about the adult felony sentencing process in the district. So to get things going and just also to start the interactive process, I'm going to ask them just true or false questions. So please feel free to use the chat just to say whether you think these statements are true or false. All right. So to get things started, who believe that the sentencing guidelines are mandatory for judges in the district? Do you think that the guidelines themselves are mandatory? True or false? So feel free to use the chat box. I see a false, I see a true, false, seems mostly false, but I see some trues. I'll give a few more people a chance to respond. This is great, guys. This is exactly what we're looking for. All right, so I see mostly falses, but some true. Those of you who said false, you are correct. The DC sentencing guidelines are voluntary. Who believes that the guidelines apply to misdemeanor and juvenile offenses? Again, true or false? Do the guidelines apply to misdemeanor and juvenile offenses? I see some falses. False. Anyone think this is true? False. False. Seems like a pretty good consensus here. So this is also false. The guidelines apply to felony convictions. We do have rules regarding prior convictions and misdemeanors and juvenile offenses, but there are not guideline recommendations regarding misdemeanor and juvenile adjudications. One more. The guidelines take into consideration the underlying facts of the case. Who believes that the guidelines take into consideration the underlying facts of the case? All right. Who believes this is true and who believes that this is false? I think I see some trues, and I believe I see a false and falses. Just want to give people a chance to respond. False, true. All right, seems like this one is a little bit more mixed. This one is also false. So the guidelines only take into consideration two pieces of information: the prior convictions of the defendant and the offense or offenses that the defendant is being sentenced for that day, and that's it. So we're going to talk more about the guidelines themselves, but I really appreciate it. This is exactly kind of the pieces of information we're going to be learning more about in today's presentation. So to get us started off with, I also want to talk about our agency that Brittany, Lyndon, and myself work for, which is the DC Sentencing Commission. So the Sentencing Commission has a statutory membership of the members on the actual commission, where we have 15 voting members and 5 non-voting members. They represent a wide variety of members from the DC criminal justice organization, whether that's judges from the DC Superior Court, U.S. Attorney, the public defender. We also have members that can be appointed by the mayor, the DC Council. We also have 9 staff members. When we are fully staffed, we are currently hiring for a legal analyst, but otherwise we have 9 staff members. Now, the guidelines and for the Sentencing Commission were created to implement, monitor, and support the sentencing guidelines themselves. As Lyndon mentioned, the goal is really to promote fair and consistent sentencing policies. When we have 2 defendants who committed similar crimes with similar criminal backgrounds, we want them to be sentenced similarly. We don't want them to receive majorly discrepant sentences based on what judge they appear in front of. We want them to receive similar and consistent sentences. We also increase the public's understanding of sentencing policies and practices in the district, and we evaluate the effectiveness of the guideline system. We receive data from the DC Superior Court regarding the sentences that are given, so we can see what sentences that the judges are providing to defendants in order to see, are the guidelines being followed? Are they not? And then what are the reasons for that? We are truly a data-driven agency, so all of our decisions and suggestions are made based on data. So some of our duties and mandates include making recommendations regarding adult felony sentencing policy, as I mentioned, and truly as based on the data we're receiving from the DC Superior Court. We also monitor the guidelines application. So again, we're receiving data regarding every single felony sentence from the DC Superior Court. We also receive data requests, whether that's from the public. We have research as well as data requests that we receive and we are responsive to. If you'd like to see some of them as well, we are also now publishing them, many of them on our website that we're able, that we think will be of interest to the public as well. We also do community outreach such as this. If you all have also probably often seen Brittany. Brittany is our outreach specialist and goes out and gives presentations as well regarding the guidelines. And then we do education and training regarding the application of the guidelines. We receive questions every day, whether from the public, judges, attorneys as well, regarding just basic questions on the guidelines or overall lengthier questions that might require deeper considerations. So we do a wide variety of things. The other thing I wanted to highlight before we start the actual training, Brittany mentioned this is part one of a two-part series. So today we're going to be talking about felony sentencing in the district. So this is really meant to be as an introduction for anyone who isn't as familiar with sentencing policy in the district or is just looking for a refresher. On March 4th, we're going to be giving a deeper, really introductory into the guidelines themselves. So we will be touching on the guidelines today, but we won't be giving the full introduction. Otherwise, I'll have you guys here for over 2 hours. So if anyone has kind of deeper questions on the guidelines, I will probably touch on them, but I'll probably also say, get excited for next week. That's what, or in 2 weeks, that's what we'll be talking about as well. So we'll be touching on that today, but the deeper guidelines 101 will be coming in 2 weeks, and that's going to be the second installment. You guys will be able to use the same Zoom link that you signed up for. So that will be coming. This is really meant to be as an introduction because that presentation does assume a level of knowledge of the DC felony process. So what questions do you all have that you're hoping to have answered today about the DC felony sentencing process? And even more broadly, so far, do you think it is fair? Just your thoughts on the DC felony sentencing process. Again, put your responses in the chat. Maybe you know nothing about the felony sentencing process. Okay, how do the sentencing guidelines get decided on? Oh, that's a great question. And then how are victims included in the process and their voice choice? That's also a great question. Any other questions that people are hoping to ask? All right, those are great thoughts so far. Learning more about the sentencing guidelines will definitely be answered more about on March 4th. But that's a great one. I can say just in general, previous sentences were considered, and then the bottom 25% was cut off, and the top 25% was cut off to try to get rid of discrepant sentences. How much precedent is considered for sentencing? That's very fair. And sentencing for minors. So again, keep in mind the sentencing guidelines do not apply to juveniles. So we're not going to be talking about juvenile adjudications today. Title 16 cases. Okay. All right. Looks like a lot of people have different thoughts. So why don't we dive in? And again, if other people feel like your question's not getting answered or you have more specific questions, feel free to utilize the chat box. So the way we find it easiest to present this is to walk through an actual hypothetical case, right? In order to walk through the sentencing process, rather than me to talk generically about sentencing in the district, why don't we walk through an actual hypothetical case and follow its process throughout? So that's how we're going to proceed through this presentation. So we're going to be talking about an armed robbery hypothetical, a common offense that we see in the district. So what do we need in order to start a sentence, right? We need an actual crime to have occurred. So the offense in our case is on November 29th of 2024 at approximately 9 p.m., Allie Smith was walking home from the metro. A male dressed all in black bumps into her, and then something hard is pressed into her back. He demands her cell phone and purse and states otherwise she's going to get hurt if she doesn't give it to him. Grabbing these items, he immediately flees the scene. She seeks help immediately at a nearby retail store who contacts the police on her behalf, right? So immediately, in order to have a sentence, anything, right, we need a crime to have occurred. So this is the crime that we're going, the offense that we're going to be following. Any questions so far? Okay. So Ms. Smith is able to provide a description of her attacker to the police, and the retail store also has surveillance cameras that captures that incident that they provide as well. So the suspect is identified as James Devon. A detective from the Metropolitan Police Department prepares a warrant, and after a judge approves that warrant, Mr. Devon was arrested and charged with armed robbery, right? So we have our crime, we have our offense, and now he's arrested, and we have what he's charged with. So the way I like to describe the DC felony criminal process is we have a series of steps, right? We first need our crime, the offense. Some crimes, the defendant is arrested on the scene, right? Maybe you have a carjacking and they're found in the car, for example. Other offenses, such as the one in our hypothetical, they're not found on the scene, right? An arrest warrant has to be issued, there has to be process, and the defendant has to be found, right? And then is arrested. So again, every case is different, but if a crime has to occur, and then ultimately they're going to get arrested, an arrest warrant. And then we have what's a very DC specific term. It's called the papering decision, okay? You'll hear this often when you're reading a Washington Post article. The U.S. Attorney's Office has decided whether or not to paper this case. That means whether they've decided or not to proceed with the case, okay? So they have the initial evidence that they're reviewing the case. They can decide to paper the case, which means they're proceeding. They're going to move the case forward, or no paper the case. That can mean a few things. Maybe the case needs additional discovery, for example. Maybe it's a white-collar crime and needs additional records that are going to take a significant amount of time. Maybe they're not sure that the defendant did it, or they need fingerprinting. It could be a wide variety of things that they decide not to proceed with the case. Maybe they will decide they want to proceed with the case in federal court. So when they no paper the case, that means that case is closed and it is not being proceeded with. Some cases, though, once they're no papered, can be brought back. When it's papered, it does mean it is being brought forward, okay? And then after that, we have really a series of what I like to call most commonly like check-ins. So each step, the status of the defendant, whether he's being held, his detainment is going to be reviewed, especially if he's being detained, right? The court is going to keep reviewing whether he should keep being detained, and the parties are going to review any evidence. Is the case moving along in the court system as it needs to? Every case is different. Some cases are very straightforward and get resolved quickly. Other cases take a lengthy amount of time, especially, say, a homicide. May have motions, may require a significant amount of discovery and take months and months and months. So it really varies. But once we're getting to the sentencing guidelines, we are assuming a defendant has either had a trial or pled guilty, and then ultimately is going to get sentenced. Some defendants also have an appeal process. This is almost always going to be based off of a trial. When a defendant pleads guilty, they are most often waiving their appeal rights. So an appeal or post-release supervision are coming after they're being sentenced. Any questions? I know I went over that kind of generally, but again, the thing to really keep in mind is each of these are kind of check-ins with the process, again, to review the defendant's status, as well as just to make sure that the case is proceeding, that evidence is being handed over, that the parties are getting what they need, and that they're communicating, that the defendant is receiving the evidence in order to review his case. Okay. So when does everyone think a defendant can plead guilty? Is there a specific time in this process that they can plead guilty? Is there a time they must plead guilty by? Are they obligated to plead guilty by a certain point? Can they not plead guilty before a certain point? What does everyone think? Can they plead guilty at any time? I see anytime, anytime. Does anyone think that it's not any time? Does someone think a defendant has to plead by a certain time or they can't plead guilty? I see a lot of any times. Usually at the arraignment, but a deal could be made later, maybe. Okay. These are great answers. Woo. So anytime is probably the most fair answer, but it's really up until the verdict is announced. So if the defendant does go to trial, they can plead guilty up until then, though I will say most of the time, the U.S. Attorney's Office will put some sort of deadline on the plea. So it may not still be available to them, but they can. There is no specific constitutional or some other requirement that says that they have to plead by a certain time. But again, they often are setting some sort of deadline so that decisions can be made. They're bringing people in for trial, for example, and things like that. If the defendant misses that deadline, it is withdrawn and typically isn't offered, or maybe not the same plea is going to be offered. The majority of cases in the District of Columbia, and I will say throughout our country, are resolved via plea agreement. Any questions? Okay. So let's go back to our hypothetical. So keeping with what is common in DC, our case is going to be resolved via plea agreement. So after discussions with the victim, Ms. Smith, and a back and forth between the AUSA and the public defender, the parties are able to reach an agreement. Mr. Devon pleads guilty to 1 count of robbery. This agreement is binding only on the defendant and the U.S. attorney. Both parties agree not to argue for a sentence that deviates from the sentencing guidelines. If you were to go sit in the DC Superior Court today and you were to sit and listen to a guilty plea, you would listen to the defendant, admit his guilt, waive his rights to certain things, and then you would watch the attorneys pull out their phones and pick dates that would be about 2 to 4 months from that sentence, okay? So why are we looking at something that's 2 to 4 months from the date of when that defendant has pled guilty? That's because they are picking a date for the preparation of the pre-sentence report, okay? Sentencing is going to occur once they have this pre-sentence report. And this is occurring after either if the defendant chose to have a trial, so that's a guilty jury verdict. Sometimes the defendant chooses to have a trial, but not with a jury. So that's what we call a bench trial. So just the judge deciding, or again, most commonly a plea bargain. So what is this pre-sentence report? So how do we think that the judge is going to go about now determining what sentence to give this defendant? Any thoughts on like what information is going to be helpful? How is the judge going to consider what felony sentence to give the defendant? What information are they going to find helpful? Do they need? How do you think they're determining in the DC Superior Court how to give a felony sentence? Prior criminal history, this great answer. Yeah. Any extenuating circumstances? Very fair. Prior rulings. Okay. So case law. Okay. Those are great responses, guys. Anyone else? All right, so why don't we dive in to see what information then a judge is going to take a look at. So again, we're talking about a pre-sentence report. Oh, we got one more answer. Prior history and characteristics of the defendant, exactly. So this is what's all going into facts and circumstances of the case. This is what's going into this pre-sentence report. This is prepared by the Court Services Offender Supervision Agency, most commonly known as CSOSA. This is a lengthy report that is ordered in almost every felony case in the DC Superior Court. It's pages and pages long. They're going to review the offense, so again, the facts and circumstances of that case. They interview the defendant. They talk to the defendant, see what's going on. They talk with the defendant's friends, family members, teachers, mentors, religious leaders, or employers, other information. If they go to jail, are they going to lose their job? Do they have obligations going on? Do they have child support or children at home or things like that? In their report, they've developed a criminal, social, family, medical, education, and employment history. They look at all of this information regarding the defendant, not just about that specific case, but are there drug issues, mental health problems, medical issues? They also look at the defendant's prior criminal histories, but also just all of their contacts. So they list not just the prior criminal convictions, but any kind of contacts with the criminal justice system. And they also provide a sentencing recommendation. So again, that's why this is pages and pages long. This isn't just the factual statement of what happened. This is a ton of information about that defendant. That's why this also takes 2 to 4 months. They're doing this for each and every case that is being sentenced in the DC Superior Court. When they are providing that recommendation, they take a look at what the sentencing guidelines recommendation is. So they're actually providing the initial sentencing recommendation based on that. And they're most often reaching out to our agency as well to confirm any questions that they might have. So this is when we're going to now talk about the sentencing guidelines, because this is when the guidelines come into play, when the defendant is now being sentenced. So we're going to talk, again, basics about the sentencing guidelines themselves. And then on March 4th, we're going to go into more information about the sentencing guidelines. But what's helpful right now is to probably have up the grids themselves, just to go over, again, the basics. So what are the 4 steps in terms of how each recommendation for any defendant is determined in the DC Superior Court? First, we're going to locate the offense severity group. That's for the offense or offenses, felony offenses that the defendant is being sentenced for. We're going to talk about how each of these steps are done at the basic level, but these are just the basic steps for how to determine the sentencing recommendation for each defendant. Then we determine the defendant's criminal history score column. This is where we get the bulk of our questions at the Sentencing Commission. Some defendants is very straightforward. They have no prior convictions. They have 1 or 2 prior DC convictions. But some defendants, it's much more complicated. We live in a metropolitan area. Some defendants have convictions from Maryland, from Virginia. Some have much older convictions from North Carolina, from Nevada. So it really varies into the complexity of determining someone's criminal history. But those are the only 2 pieces of information that come together and then that determine the guideline sentencing range and sentence type, okay? Sometimes an enhancement or special rule applies, and we'll talk about that briefly, but it's just helpful to know the guidelines, to talk about that. Those are in much rarer circumstances. Brittany also put a link up for the grids, so if you do want to follow along, I'm going to have them up throughout the presentation, but if you want to pull them up, the link to the grids, so you can also do it yourself, is on the chat right now. So thank you, Brittany. All right. So on your screen are our 2 grids. They work in exactly the same way. We have our drug grid on the left of your screen, which ranks all felony drug offenses in the district. We have our main grid on the right, which ranks all other felony offenses. So offense severity group 1 on both grids is the most serious offenses for both. So that's distribution while armed with any drug and possession with intent to distribute while armed with any drug for drug group 1, and first-degree murder while armed and first-degree murder on main grid, on offense severity group 1 on the main grid. Then you're moving down in severity until you get to main grid offense severity group 9, or on the drug grid, that's just offense severity group 4. Okay? Then you move across for criminal history score, and we'll talk about that in a minute, but they work exactly the same way. So when you're determining the offense severity group for the offense or offenses, you're looking at what that OSG is, and you figure out what column you're in. So let's first figure out then what the offense severity group is for our hypothetical. So as I mentioned before, the commission is only going to rank felony offenses. Some cases, the defendant is convicted of both felony and misdemeanor offenses. There is only going to be a recommendation for that felony offense though, okay? So who recalls what James Devin's offensive conviction was? Just add it in the chat. Does anyone recall in our hypothetical what he pled guilty to? Robbery, robbery, robbery. Anyone think it was anything else but robbery? I see an armed robbery. All right. So the reason we asked this question, and I appreciate the armed robbery, because the key to keep in mind is, right, I presented this as an armed robbery hypothetical, right? And you often see this come up in the news, right? Someone was convicted or committed an armed robbery, but they were sentenced for this. When we are figuring out the offense severity group of an offense, what matters is what they were actually convicted of. So what they pled guilty to, what they were found guilty of. So while Mr. Devin was initially charged with armed robbery, he pled guilty to robbery, and that can be for a variety of reasons, okay? So what the offense severity group, though, is going to be what he actually pled guilty to. So those of you who said robbery are correct, but I really appreciate the person who said armed robbery, because that is exactly the point, because I think a lot of people assume it's what's based on what was initially charged or based on the facts, and there are some sentencing commissions where it is a much more factual determination. But what matters for the DC sentencing guidelines is truly what the statute is, what the statute of conviction is. So in our case, it is going to be robbery. So everyone take a look at your grids and tell me what offense severity group robbery is in. I promise it is on your grid. Yep. Great job, guys. So robbery falls in M6. So that's where we're going to be looking now for Mr. Devin. Great job, guys. So everyone see how we're getting that? So not all offenses are on our grids. We also in our manual have all of them listed out in Appendix C but again, to keep things simple, we're just going to be looking at what our grids are. Our grids list out the most common offenses that you are going to see sentenced in the DC Superior Court to kind of keep things simple. All right. Now that we have our offense severity group, the next step is determining the criminal history score of the defendant. So as I mentioned, both grids work in the same way. We have 5 criminal history score columns, A through E. A is 0 to very little criminal history score, and then you're moving across. And both grids have the same ranges, okay? So they have, column A is the same on the drug grid as it is on the main grid, okay? So 6-point plus E is the same on the drug grid as it is on the main grid. These are entirely based on a defendant's prior convictions. As I mentioned, the PSR is going to mention really every contact a defendant has, but the only potentially scorable are prior convictions, so actual findings of guilt. Now, this is initially researched and scored by CSOSA, but the final score is determined by the court. So sometimes that score is updated, and that is entirely part of the process. So the score may change slightly, and that is entirely to be expected. So in order to determine what the prior points are that are going to be attributed the main way to consider it is based on the offense severity group of that prior conviction. So as you can see on your grids, we also list criminal history points right next to what the offense severity group is. So groups M1 through M5 are 3 points, M6 through 7 are 2 points, and then M8 through M9 are 1 point. And then you can see from our table that once you add up, you can figure out what column someone is in. So if I tell you that Mr. Devin has a criminal history score, prior conviction for attempted robbery, how many points would that give him? So what you want to do is then find attempt robbery on your grid, and it should tell you how many points he would have. I see one answer. Anyone else? Yep. Just want to give other people a chance to respond. See if anyone else sees anything different. So far, it looks like everyone thinks he has 1 point. Does anyone else think anything differently?
Also, if you are struggling to see, I did put a copy of the grids in the chat, and I'll do that once again. I see you guys squinting. I don't want you to strain your eye.
Yep. No, feel free and take your time. I'm not rushing through this. So giving everyone a chance to look. I see someone who said 2 points. 1 point. All right. So for those of you who said 1 point, and Brittany just put the sentencing grids back on the chat. So again, if you didn't get a chance to click on it, please feel free to click on it. Thank you so much, Brittany. So the 1 point is correct. So it is, right, we can see attempt robbery is right here on M8, and it is 1 point, okay? And this is his only prior conviction. So if he has 1 point, does anyone want to tell me then what column he would fall in based on the chart on the screen? Yep, column B, exactly. So it's just that simple. We add up all the points and we figure out then what column he's going to be in. So great job, everyone. The other piece of information that the grids will give us is also a sentence type. So as you can see, our grids provide a range, a number that the defendant can be sentenced in, but it also comes with colors. So I'm going to go very briefly through what the sentence types are, but again, on March 4th, I'm going to go into much more depth of how the sentence types work, okay? But very briefly, our different sentence types are prison, which includes a long split, short splits, and probation. So the way the different colors work are, a prison and long split sentence are available in every box, but they are the only available sentence types in the white boxes, right? These are the most serious offenses or the highest criminal history score. Short splits are available in all blue boxes, so the light blue and the dark blue, okay? Probation is only available in the light blue boxes. So how do we go about now finding the right box? So we've just done all the initial steps. Oh, can I explain splits again? I'll go very quickly, but again, I'm going to go in much more depth. If anyone has preliminary questions on splits, but I'm going to go and walk through how to impose a compliance split sentence on March 4th. So I'm going to kind of hold off on that. I'm really glad you guys have questions, but I have lengthier examples about how to impose compliant long splits, but let me walk through this one more time, guys. So the way that the grid colors work are all boxes have prison and long split available, but they are the only sentence types available in the white boxes, okay? To think of them briefly, the defendant must serve in those white boxes at least that bottom number. In the short splits are available in all of the blue color boxes. So that's whether light blue or dark blue, okay? They're not available in the white color boxes. That defendant is going to serve 6 months or less. I'm giving a very brief way of explaining this. This is not the full explanation of splits, but just to give you kind of an idea. And then for probation sentences, it is an entirely suspended sentence, and that's only available in the light blue boxes, okay? And that's entirely suspended. Keep in mind, though, these are available sentence types. So even though, say, probation is available in this 8A box, right, the 6 to 24 month, the commission is not saying you must give a probation sentence. A judge could give a prison sentence in that box. There's no recommended, required, you must give this sentence type. These are available sentence types. We've seen long splits in boxes where a short split is available. There's no requirement a judge must give probation. These are all available sentence types. The options become more limited the more serious the offense is and the more and the higher the criminal history score is. I will go again in more depth, but if there are more specific questions at the end of the presentation, or again, you're welcome to send a question. We also get common questions just regarding how to impose these types of sentences all the time. So if you have a question just regarding your specific case, we can't give legal advice on a specific case, but we can give information on how to impose compliance split. So feel free to also send an email after. All right, so let's get back to our hypothetical, right? We know now how to go back to our grids and find this information. So we know how to find the offense severity group, right? So we know that our defendant was convicted of robbery. So he's an M6, right? So we know now what column we're in. And as everyone correctly pointed out, we also now know with his prior conviction for attempted armed robbery that with his criminal history score of 1, he's in criminal history score column B. So you take those two pieces of information, and that's where you find what box a defendant is, okay? So based on that, we figure out what the recommended sentence range is, which in this case is 24 to 66 months. And then that box also, based on the color, gives us a recommended sentence type. So in this case, the defendant's recommended range, again, is 24 to 66 months. And based on that, he also is recommended a prison or long split only sentence. Everyone understand how we got there? Any questions so far? Please feel free to ask questions. Honestly, if I don't see questions, I start to wonder if I'm doing this correctly, guys. So please feel free to ask any questions that you might have. All right. So what are the parties' roles now that they would have a sentencing recommendation, right? So from the pre-sentence report, So both the prosecution and the defense attorney have a role in this. So both can submit a sentencing memorandum that include a sentence type and length recommendation. The prosecutor at that time can provide a victim and community impact statement. The victim can speak at the sentencing hearing as well. They may not choose to give something as part of the sentencing memorandum. The victim really can choose how much they want to participate in the sentencing process or not. Some victims, once they know that the defendant is pleading guilty, don't want to proceed any further and participate. Some victims want to participate more. It really just depends on the victim, but they definitely have a voice. They can, in their sentencing memorandum, the U.S. Attorney's Office includes any other information that they believe is relevant for the judge to know. So that can be case law, it can be anything else. And then at that time, they're advocating for a specific sentence or sentencing range. Probably will shock everyone to know that this is likely not going to be the specific sentence or sentencing type that the defense is going to be asking for, right? This is still an adversarial case. The defense also can make a sentencing memorandum. These are not required. I would say the more serious the case, the more likely you are to see sentencing memorandum from at least one, if not both of the parties, but sentencing memorandums are not required. They can, the defense can take a statement from the family members and friends from the defendant, maybe from their church or things like that, that speak to the character of the defendant and any other relevant information. They can also provide prior case law that might be helpful and things like that. And then again, they're advocating for a specific sentence or sentence range. Now, as I think a few people mentioned in the comments, right? There are also the specific facts to the case, right? The guidelines take into consideration only two pieces of information. So in some cases, the judge may decide to go above the guidelines, and we call that citing an aggravating factor, right? They take a look at the guidelines and they believe that it's better to go higher than that recommended sentencing range. Can anyone think of a reason why a judge might decide to go above the recommended sentencing range? Just feel free to include in the chat a reason you think a judge might think it's better to go above what the guidelines recommended. Repeat offender, hate crime, okay. Any other reasons? Prior history, extreme serious injury to the victim. Yep, these are all spot on, guys. Lack of remorse, yep. Deter from future crimes, okay. Vulnerable victim, child victim, victim statement, yep. Be impacted by that, fair enough. All right, so same thing. The judge could also take a look at the case and decide that the guidelines are too serious, that they are too harsh in this case, and that they believe that they should sentence more leniently, so that they should go below the guidelines recommended sentence range. So can anyone think of a reason why the judge might decide to go below the guidelines? Youth Rehabilitation Act, that's fair. So that would really be the age of the defendant, and that's fair. I do want to be clear, the YRA is not its own mitigating factor, but the factors under the YRA are often cited, yes. Medical issues, fair enough, yep. Medical issues of the defendant. Anyone else? Mitigation history of poverty, trauma, and abuse, statements from family, elements of the offense don't rise to the crime. So keep in mind, right? Mitigating or aggravating is separate. The defendant has been found or pled guilty. So this is not to say that the defendant now is where we're relooking at the guilt. This is just other information or facts that either the judge has found aggravating, but maybe haven't risen to an aggravating factor that is an actual statute, or mitigating where, right? So to say the elements of offense don't rise to it, then that would mean that they wouldn't be found guilty. So this is kind of a wiggle room, right? Where there's some other factor that maybe means maybe they wouldn't be as culpable. For example, victim advocating for a lighter sentence, not the initial aggressor. That is definitely one. So on our screen are some of the most common aggravating and mitigating factors the guidelines have specific ones listed as well as just catch-alls, right? There may be a specific reason in that case that aligns with some of these factors that, again, the guidelines can't come up with every fact in every case, but exactly what everyone was talking about. So for aggravating factors, right, deliberate cruelty to the victim or gratuitous violence, right, the injuries to the victim. Maybe the victim was particularly vulnerable. Someone mentioned a child victim or maybe an elderly victim. The victim sustained a devastating injury. Maybe the crime was substantially premeditated, right? Mitigating factors. The victim was the initial aggressor, or the defendant acted under duress, coercion, threat. The offense was principally accomplished by another, right? They've met the elements, but there are other considerations here. The defendant provided substantial assistance to law enforcement. That is the one we most often see cited. The defendant was induced by others to commit the crime. So there are other reasons why, again, maybe they've met the elements of the case, but there might be other factors why the judge decides to go below. So taking all that into consideration, then we have the sentencing judge who's going to take a look at the PSR. So at the sentencing hearing, the judge is going to review the PSR, finalize the defendant's criminal history, analyze the defendant's performance on pretrial or prior supervision, review the victim or community impact statement, review the recommendations of the prosecutor and the defense attorney, listen to any arguments. Someone mentioned, right, the arguments of the parties, even what the victim's going to say. Then evaluate any other relevant information. And that's when they're going to take a look at the voluntary sentencing guidelines recommendation. At that time, the judge can also determine they may choose not to follow it. Remember, the guidelines are entirely voluntary. Judges are only obligated to give a legal sentence. They do not have to follow the guidelines. And at that time, they're going to give a sentence. So let's go back to our hypothetical and wrap it up. So in our case, right, remember, the defendant was recommended to be given a lengthy sentence, right, because of his prior criminal history. So in our case, the defendant was convicted of robbery. He pled guilty. So it's going to be a sentence of 50 months, suspending all but 24. And he's going to receive 4 years of supervised probation and be ordered to stay away from Ms. Smith. If he were to run into her, he needs to turn around and go the other way. If he bugs her in any way, that would be considered a violation of his probation. Keep in mind, robbery also has a statutory minimum of 24 months. So he would have needed to at least receive some amount of that time. That could have been suspended, but to receive a guidelines compliant sentence, he actually has to serve all of that. All right. I'm going to go over this part really briefly, just because for the sake of time, and I want to make sure I give everyone an opportunity to ask questions. But as I mentioned, we are a data-driven agency. We're actually currently working on our 2025 annual report. So this is just a brief preview of some of the data we did last year for our 2024. So we give information of sentencing trends over both the past decade as well as that year. So as you can kind of see, the cases sentenced from 2015 to 2024, there's always that dip because of COVID and the closures of the court. But as you can see, as the court rebounded and started hearing and handling cases again, and then we also saw an increase in 2024. We also evaluate compliance as well as just what offenses are being sentenced, including the offense severity group. So most offenses we're often seeing being sentenced are in offense severity group M8. We also look at the sentence offense type, whether it's homicide, sex, violent, weapon, property, drug, or just other. And again, just what the sentence counts are and their trends. And that's just some basics. So again, I went through that very quickly. If you have more interest, again, we have our annual report online. We're currently working on our 2025, and we'll be giving a public presentation on that as well coming up. But our next presentation will be on March 4th, and that will be a deeper dive into the guidelines. And that will be at the same time utilizing the same link. I also recommend, if you have an interest in the commission, learning more, Brittany updates all of our social media. And I also recommend signing up for our newsletter. You'll hear all of the updates regarding new manuals, if the commission has any updated information, as well as all of our social media channels. But I'm happy to stay on for any additional questions you have. My email, as well as the email for the agency, is on the screen. So if you have a particular question as well, if that's easier to ask. I know that this is a large group, and we are truly, truly appreciative of everyone who came and took time during their lunch hour. But we're happy to answer any and all questions, but we truly, truly appreciate your time, and we hope to see you March 4th. So thank you all.